Well, welcome back to Real TMI, where Jordan and I discuss real estate issues. Jordan, I need you because this is your
I'm
wheelhouse,
here for
man.
you.
I am paying attention and I keep hearing all these rumors about the NAR settlement being appealed, getting rolled back, that it might just go away. Like, let's clear up this conversation. Let's get to the facts. What is it that you know?
Yeah. Well, yeah. So as we speak right now in St. Louis, so a couple states away, there is a panel of appellate court judges who are hearing the appeal of the NAR settlement from 2024. When that settlement was finalized in November of 2024, instantly you had some appeals that were filed, and they've done their process, and they're finally now getting in front of the panel of judges, hearing the case today, and then it will be like sometime in the spring when we find out any decisions, if any, that are made from it.
But okay, so I thought this was done. I thought that we all agreed. I thought that the settlement was done. I thought class action meant that nobody else can show up. Like, why are we here? Like, because I don't understand how we end up here looking down the barrel of a possible, like, reversal going back through the whole negotiation again. How do we end up here? Was that what you just explained? Like,
Well,
I'm just lost on the class action, how that we end up back in it.
but that's what you're saying, the key phrase there, class action. And so part of the settlement agreement, when you're dealing with an issue that can become a class action or is part of a class action, then there are other entities who may not like the settlement because it constrains them. And so we can rewind it back to when all this began with 2019, when the lawsuits started getting underway. And the main lawsuit that ended up being what was settled, it was Sitzer Burnett. And that was filed in 2019. You go through a process, and then in 2023, you have a jury verdict in that lawsuit, and they side with Sitzer Burnett against NAR and the MLSs, and that then is what really opened the floodgates, where you have a jury deciding, oh, NAR has done wrong, the real estate industry, it has harmed the public. Then copycat lawsuit after copycat lawsuit gets filed, all as class actions to go after every association and MLS around the country. And so then it's like, okay, NAR gets with the plaintiffs, it's Sitzer and Burnett, and they reach a settlement of, hey, okay, so the jury has said, you guys were in the right, we messed up, our bad, let's find a solution here that everybody can move forward with. And they reached a settlement in 2024. And those two parties to it were on board with it all. But you have all those copycat class action lawsuits and other entities who have a vested stake in the outcome that, okay, the settlement doesn't necessarily satisfy them. So they don't want the settlement to actually be what holds for the long term. They get in, they do their appeals, and that's what's happening today is those are being heard.
I didn't think this is how this would work. I thought that, once it was done, it was done. That's what NAR said to us, right? That's what we read when NAR said, hey, we've settled. We're protecting everybody moving forward. We're done with this. And now we're talking about appeals. And so in your mind, you are not a lawyer. You play one on TV. Do you even
No,
play one on
I
TV?
don't even, I'm not an amateur lawyer, even on the internet. I am not at all.
Right.
I have no legal background.
But how likely is this a flash in the pan? Is this just something that realtors are starting to talk about because they kind of heard about it? Is that what this actually feels like?
So, I mean, yeah, there's the real estate blogosphere where some different authors are out there writing stories about how, yeah, if this goes one way, then it could be very disruptive, because here it's been a year and a half of the new practices that we've adopted as a result of the settlement. And all of a sudden, all of those changes may become kind of moot. So to go into the details of why the appeal is there, you have two different strands of arguments for the most part. There's a law professor who's put forth the argument that the settlement wasn't enough for the plaintiffs because the damages, the back of the napkin math works out to like $16 per person.
Right, which
But
isn't a game changer. It's like,
right,
"Oh, cool, glad that we got 16 bucks. Thanks for my Big Mac meal."
right. Yeah, but this is the realm of class actions where when you have a settlement, the per person amount is not likely to be substantial, in part because, yeah, the defendant side, they aren't unlimited funds. There's
Right.
a their resources are limited, and so when the lawsuit, it was for $458 billion, and NAR, you know, is not a multi-billion dollar, they can afford a $458 billion lawsuit or judgment. So the settlement was that, yeah, NAR is paying about 400 something million, and then there's other defendants that also were part of the settlement. So it was about $1 billion in restitution that was incorporated into the settlement. Main reason for the plaintiffs willing to settle was because there's the injunctive relief moving forward, which is the changes to our industry practices. That was
Mhm.
really what the other side was agreeing to, as accepting of the fact that the money isn't there to try to make whole $11,000 per individual that could be part of the class action lawsuit.
Yeah,
So
imagine going from $16 per person to $11,000 per person in this whole thing. Nobody could ever afford to pay that out, right? That's what you're saying.
right, yeah.
Yeah.
And so it's like, okay, yeah, if this settlement wasn't agreed to, and instead the plaintiffs wanted more money, and then it's kind of like, okay, if on the defendant's side, at some point you're just going to be bankrupt. And so what's the point of settling at that? But it's like, okay, yeah, we're going to change the way in which we operate. We're going to have the buyer agent compensation. It's no longer going to be on the MLS. It's going to be negotiated between the buyer's agents and their clients up front before any sort of offers are written or even showings occur. And so we have then, as an industry, adopted those changes that were outlined in the injunctive relief. But the appeal, well, there's a couple different appeals, but one of them was focused on how those changes aren't big enough. And their focus is more on, because you have other lawsuits occurring concurrently with the Sitzer Burnett one. The big other lawsuit is Batten, but that was dealing primarily with buyer agency and buyer clients. So they wanted to be, the reason they've appealed the settlement is they don't like the language of the settlement, because their view, and I am hoping that their view is correct, that the settlement is protecting NAR and all the associations and brokerages from further lawsuits, not just from sellers in the past, but also buyers. And so that's the question of, okay, is it only appealing? Well, who is the class in the class action? Is it just sellers that have sold in the past 20 years, or does it include the clients on the buyer side of the transaction? If not, then those are potential additional class action lawsuits, and we could just get hit with another penalty or settlement where NAR has to pay a whole equal amount or more, whatever, an additional class of the public.
So let's dumb this down a little bit for those of us that need it a little bit more in layman's terms. You're saying the Sitzer Burnett case, there is one of the people fighting against this and appealing it is saying, we believe this only protected sellers. And
They
so,
want it clarified that Sitzer Burnett only applies to sellers, so that way then NAR can't be sued by any additional sellers for those transactions.
but they want it clarified that it protects sellers and sellers only.
That it only covers the sellers, and so NAR can't be sued anymore by sellers, but they want to leave that door open for buyers to still participate in a class action lawsuit against NAR. So that's where, ostensibly, I believe the settlement was meant to only be for sellers.
Right.
I don't, I, that's beyond my pay grade to know exactly, how it will be interpreted. But that is one of the things the appellate court is looking at, is what is the interpretation of the settlement language? Because if it is unclear, then you can't have that uncertainty or vagueness in our justice system, because a lot of money rides on the outcome.
Yeah, so let's move into the realm of possibilities then.
Yeah.
So, say it is decided that it is sellers. We could go through all of this all over again on the buy side, where buyers can say, I didn't know that the buyer's agency commission was negotiable and that I could have used that to negotiate trying to purchase a house. It opens the door. It's the muddy water that was the whole point of the original lawsuit. They're like, wait a minute, I didn't know that I could negotiate with my own agent on what the commission was going to be. I didn't know I could negotiate what the commission would be that I'm paying out to a prospective sell side agent, right? That's where all this kind of begins. That's the nuts and bolts of this original lawsuit. If that one goes through, the buy side stays open, we could go through this possibly all over again.
Right. Well, and with these lawsuits, I mean, they take years for them to go through the system. And so
Right.
that's why, yeah, what a lawsuit that began in 2019, the jury verdict comes in 2023, then the settlement a year later. Appeals to that settlement are just now being heard. So it's if there is another class action lawsuit that is a liability to our association in our industry, that we have to go through this whole process again. I mean, it may take several years for it all to work out, but it does then provide additional uncertainty as to, okay, if that is going to also result in a settlement, what sort of industry changes would come to satisfy that one? Because the injunctive relief is important aspect from a real estate agent and brokerage side of things, because that's what is determining how we move forward with
Hmm.
our best practices. The money side of things, it affects our association and the dues that we're paying, but that doesn't impact us as directly as the changes to
Yeah.
how we operate.
It changes how we operate, right? And again, you said this, like, out of the whole original lawsuit that we settled, I mean, really the public is really, the damages that they're receiving is like 16.
Yeah. So, I mean, there's 40 million members of the class action lawsuit in theory.
Yeah.
I mean, it's not the class action lawsuits, the money goes to the lawyers. It's not
Hmm.
like it's gonna end up getting to the public in a way that really benefits the public in a way to make them feel like they were made whole. But the lawyers along the way, and hence why, I mean, the attorneys for the Batten lawsuits, I mean, they have such a vested stake in the outcome as to what this appellate court decides, because yeah, if the appellate court doesn't intervene and change the settlement, then maybe that all their lawsuits end up becoming null, and then they don't get paid. And so that law firm needs the ability to continue proceeding with additional lawsuits against NAR in order for them to get compensated. But
Cool.
just like with the Sitzer Burnett settlement, even if Batten is successful, it's not like the members of that class are likely to receive more than $16 a person.
Cool. And I want to dive into this next thing. So we've been living how long? A year and a half now post settlement, and we've operated and we changed and we do things differently to make sure that we're adhering to what the settlement was. Jordan, I don't see it benefiting the public in any way, the changes. Do you?
No, I mean, I don't see it honestly making a substantial impact in how we operate in most situations. There was an expectation that agents would be communicating ahead of time before any showings occur to try to find out what sorts of compensation is being offered up front. Okay. I think most agents have gone down the path with fewer hurdles, which is they negotiate with their client to get a buyer contract signed up front with the buyer compensation spelled out, and then they're writing offers asking for the sellers to pay that compensation they had negotiated with their buyer clients, because the buyers can get credited for whatever is negotiated as part of the purchase agreement. But they don't need to know upfront what the sellers were offering to pay. It's another term within the purchase agreement that's negotiable. And
Yeah.
I actually don't think that that's a bad thing at all, personally. I think it hasn't I haven't seen it really change what the compensation is. So it's not like, the claims of, had these changes been around decades ago, the sellers would have saved $11,000. I'm not seeing.
Yeah, they're not doing it now. We have a year and a half of proof they're
Right.
not saving $11,000 per person.
Right.
Actually, some of the statistics we've seen is the base buyer agency commission has actually gone up since the settlement by like a 0.1% and things like that. Like it's relatively held steady to what it was prior to the settlement, if not gone up a tiny bit. So this feels like something that just ended up being something that paid a bunch of attorneys to me.
Yes. Yeah. And the irony of one industry where their compensation is pretty standard of, 25%, 33% of what they win, them going after another industry because our industry had a standard, typical commission percentage. It's like, yeah, the pot calling the kettle black here.
Yeah.
Yeah, and just as they have freedom to charge their clients a different percentage, we do too, and we can negotiate it. But just because there's an expectation in our industry, I found it a bit ironic that the attorneys were just trying to harm what we do when they do the same thing.
Yeah. All right, Jordan, let's start wrapping this up, but let's have this conversation. What should we be paying attention to?
Well,
What are
yeah.
we watching out for? Does this mean anything? Is this just a news cycle thing? What are
So
we looking for?
in the spring, we should receive the results of today's hearing, whatever the appellate court decides. And so if they decide that the settlement is all fine and dandy, then yeah, nothing changes and everything's good. If they decide that the settlement needs to be vacated, then there's a couple different paths we may go down. It depends on, is it just a broad brush, no settlement's no good, send it back down to the district court, then the parties involved have to try again? Or is it that they're finding that there's some aspect to it that's inadequate, like with the claim that, okay, to specify the language of who this settlement covers as far as other class action lawsuits, they may just say, yeah, send it back down to the district court, rewrite it to better clarify who's participating in this settlement and who it applies to. And so that's all that happens. And then everything's good moving forward at that point. So it depends on what the court decides in the spring. But my expectation, the money side of it, I don't foresee a court trying to tell NAR like, oh, rather than 400 and something million, which they've already begun paying. They made a payment last February. They're make another payment this February. The idea that, oh, now it's going to be 10 or 100 times what was in the settlement. I mean, that NAR would be like, we don't have it, and you're just destroying our association and our industry and all the stuff. So I don't foresee the court doing that. I think it'll be, if they decide anything, I think the argument's about clarifying who it covers. That's where we may see some changes.
Well, cool. Well, this was super helpful, man. Thank you for explaining it to me. I kept hearing about it all day, and I'm like, wait a minute, what is happening? So that's why I reached out to you to see if we can have a
Yeah.
in-depth conversation, get rid of all the distractions, and be like, hey, what is going on? So I appreciate you having this conversation and being so knowledgeable on this subject. I know you spent some time today reading into it, researching, so I appreciate you, man.
So I guess we'll leave it there, and we'll be continuing to watch to see in the spring what they say. So that's a real TMI for you.
All right, that's the real tea. Talk to you guys later.
See ya.